मेंशन करना देंगे,
पता नहीं देंगे या नहीं देंगे सर आप
नहीं स्टार्टिंग में कर रहा हूँ,
क्या करना चाहते हैं?
मेंशन करना।
देखिए सर, पता नहीं क्या कहेंगे।
नहीं
Some written submission.
हाँ, रिटन सबमिशन कर देंगे, काइंडली अलाउड। Lordship, we have filed the written submission after the due date, so kindly allow the nodal officer to forward it to the court master and update in the proposal.
But on the time period, this is a little scary because we have a suggested timeline of 12 hours and some 45 minutes. I don't think we have the luxury of time, not 12 hours. I don't think we'll be able to spend 12 hours on this.
Sir, humble
We were
It
hoping,
may spill over to tomorrow.
we were hoping that we'll complete it today, but if there's a spillover, we'll complete it in any case tomorrow.
Tomorrow. After the other 7, 9 and 10.
That won't take very long. They will
It's
just
more
have to pass
housekeeping,
procedural directions for, compilation.
So we take it that if it doesn't get over today, then after those 7 and 9,
Of course, yes.
this will continue.
Yes, absolutely.
The permissions to upload 4C and 5D. Volumes 4C and 5D.
You want to add some volumes. What are those? What are they, Mr. Sakadande?
In 5D, there are 2 judgments. And in 4C, there are some enactments.
Enactments, yeah. All right.
Well, similarly, there are 1 or 2 other judgments which we want to cite.
Give them to the nodal council so that they can then, sort of put them together in the right place.
Look, may I also have liberty? My submissions, I noticed there's a mistake. I've just corrected that the wrong case has been cited. Maybe I have liberty to correct that.
You can certainly correct. Tell the nodal council, he'll replace it.
Well, then 1 more replacement that I would need is a typographical error that's kept into my written submissions. Well, I'll just email the correct version. Thank you.
Yeah.
Yes,
Lord, yes. At the outset, Lord, I will be dealing only with the Stamp Act and the Contract Act. To save time, Lord, my colleagues, Mr. Saturdande and Mr. Mehta will deal with the arbitration aspect. Then your Lordship may decide the sequence, whether the amicus gets into it or Mr. Kambata gets in, the Lordship may decide the sequence. But I'll take as little time as possible because focusing only on 11.6a, the Stamp Act and the Contract Act in that sequence. Now, my Lord, I also wanted to mention that on the curative part, Lordship 7 judges will decide the main issue of the correctness of NNG2, NN Global 2.
Yes, of course.
Yes. And then, my Lord, whatever your Lordship verdict, the curative can again go back to the 5 judges, then we will see what is to be done. That's my suggestion, my Lord, because in this bench, I'm saying my humble request is let us not go into the curative part because we won't have time also on that. So that.
Because that may depend on the individual
Yes,
facts,
I want to say
etc.
yes, because if your Lordship sets aside NNG2, then there are certain consequences. If your Lordship upholds NNG2, volume 1 of all these. Sorry.
Yes, Mr.
Yes. Now, my Lord, volume 1 are the written
In our turn,
submissions.
Manoj, we'll be addressing your lordships on curative jurisdiction. In our turn.
We are inclined as of now to send the curative issue to a bench of 5. We lay down the principle, correct, decide the correctness of NNG.
Anyway, your lordships will hear us. I don't want to interrupt the flow. I'm going to definitely address your lordships on this present jurisdiction which the court is exercising.
Certain.
Yes. And my Lord,
Yeah, that's very funny.
Lord, on the issue of curative, apart from Ashok Hura, my Lord, Lordship will also take it that there is one more judgment of Justice Dalbir Bhandari, Indian Council for Enviro Legal Action. Lord, depending on what Mr. Shyam Devan says, I'll respond to that, Lord.
On to that and rejoin.
In reply, that's all.
Yes.
No, I'll straight away start. Lordship has got my written submissions, which is in volume 1. Now, my Lord, the first submission I'm making is, if your Lordship sees section 11.6a of the Act, Now, my lord,
Where do we get that in the,
Yes.
in the compilation? We
we
can
will be
also,
using it again and again, so we'll take that.
it would be in volume 4,
Bookmark 9,
4A.
yes. Take it. Page 1210,
Page 1220.
yes. But I want your lordship to notice one thing at the outset, that section 11 has a marginal note for appointment of arbitrators. And though the law is that marginal note may not necessarily control the interpretation, but it is definitely an aid to understanding the scope of the section. Just to set the record complete. Yes. As far as marginal note is concerned, I must just 2 minutes on the law. Earlier view was marginal note cannot be used in interpretation. That was the
That's
law.
not the view.
That's not in 2005. The House of Lords completely changed it and said that look, definitely we can consider what is the scope of the section, what is the intention that's there.
And the reason in England was that a marginal note was never part of the original statute
Yes,
when it was
for the
enacted
bill,
in
yes,
Parliament.
Yes.
In India, marginal notes are part of the draft bill which is presented
Yes.
to Parliament.
In every finance bill, you'll have the marginal note also. So, my lord, let's take that marginal note. I'm just taking one
But
point.
it's not conclusive.
No, not at all. It's persuasive. Even Justice Subbarao and 59 said, yes, where there's ambiguity, we want to understand the scope of the section, we'll get it. But for our purposes, we can take, my lord, it is discussed in GP Singh, 15th edition, at page 133 and 134. The earlier law is mentioned and the later law is mentioned. But due to shortage of time, I didn't want to get into that. Yes, my first submission is the section reads appointment of arbitrators. Now, if your lordship goes to 11.6a, 11.6a is a case where the Supreme Court or the High Court are considering applications under 3 subsections. That is subsection 4, subsection 5, and subsection 6. And lordship will find that in all these subsections, there is basically a deadlock in the appointment of an arbitrator. Either the parties cannot agree to it, or the 2 arbitrators cannot agree to a chairperson. And then, my lord, the court has to step in, resolve the deadlock and say, let not the arbitration procedure be stymied by this. We are appointing so-and-so and move on. So, my lord, my submission is the purpose of 11.6a is to remove the deadlock, so to speak, which arises, which necessitates an application in 4, 5, and 6. So that's the second point I'm making. Now, my lord, comes to the, sorry.
Yes.
My lord, now if your lordship comes to the main section 11.6a, which will be the bone of contention here. After referring to these subsections, lordship will note the very important point is a non-obstante clause, notwithstanding any judgment, decree, or order of any court. So obviously Parliament knew, as per the Law Commission report, S.B. Patel and the line of cases, where there was a duty cast upon the court also, not just to see the arbitration agreement, but to go further, see issues of validity and so on, because then they said that there is no point in referring a matter to arbitration which has so many defects. We'll clear it, some kind of a filter process, and then we'll send it. So they first say, notwithstanding any judgments, therefore the basis of all the judgments stand removed by the non-obstante clause.
It doesn't override any other statute, though.
Pardon me?
It doesn't override any other statute.
No. Because there was no other statute coming in the way. I'll come to 33(2) later of the Stamp Act. And my lord, very unusually, the other point I'm making is that section 11(6)(a) jurisdiction is not an inherent power of the Supreme Court or the High Court. It's a confined jurisdiction. The jurisdiction has been confined by Parliament. And the contours of the jurisdiction have been restricted to examination of the existence of an arbitration agreement. Now, my lord, the statement of objects and reasons is set out in the Garware-Waldrop's judgment, which your lordship will find in volume 5A. Now, my lord, volume 5A and 5B contain all the cases, my lord, main cases. And if your lordship comes to the Garware-Waldrop's judgment, volume 5A, it is in page 50. Lord, judgment starts at page 33 of volume 5A.
53.
Page 33, my lord.
Volume 5A.
5A. Now, my lord, this judgment has been followed in NN Global. And this judgment is relevant because it is the post 215 case. And if your lordship straight away comes to para 50.
Para 50.
Para 50.
Which page number in volume 5A?
Sorry, page 50. Page 50, para 13. Sorry, my apologies. My lord, lordship will find, my lord, para 13. The statement of objects starts from para 6 if your lordship notes. My lord, if your lordship sees the actual statement of objects and reasons, the earlier paragraph mentions that India is 179 out of 190 countries in the index of doing business. This can't go on. Therefore, we have to simplify the procedure for ease of doing business. That's the earlier part of it. But now come to para 6 and subclause 4. To provide that while considering any application for appointment of arbitrator, the High Court or the Supreme Court shall examine the existence of a prima facie arbitration agreement and not other issues. So they have expressly mentioned not other issues. And that is very important when I come to section 33, subsection 2 of the Stamp Act. For the time being, Parliament is very, very clear. And lordship will note, they drop prima facie when the actual 11(6)(a) comes, but prima facie is continued in section 8 and in section 45. But the net result is the court shall confine itself to the examination of the existence of an arbitration agreement and not other issues. Now, lordship, where's my written submission? Lordship will also so therefore see the non-obstante clause, the word confine, and only to the existence of an arbitration agreement. Now, if a lordship just goes to section 7 for a minute, you can have three possible situations.
we go back to,
Section 7 of the Arbitration Act.
we go to volume 4A, which we
4A.
opened up. Then section 7. We have opened volume.
One 207. May I read? No?
Just one second. Yeah. Yes.
In this part, and Lordship will kindly see, arbitration agreement actually is defined in 2A to mean arbitration agreement means an agreement referred to in section 7. So the definition shifts the scope of the provision to section 7. So to be read with section 7 is the definition of arbitration agreement. Arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. So, my lord, it's in this small subsection, there are numerous parts which my friends will deal with. So, arbitration agreement is to submit all or certain disputes. So, Lordship knows there are something called accepted matters, that some matters will not go to arbitration, which may arise in respect of a defined legal relationship. And this, the New Zealand court says, defined legal relationship is because we don't want to keep it very, very vague and broad. You should have a defined legal relationship. That is the point, whether contractual or not. So even if it's not contractual, and I can only think of, say, for example, a quasi-contract under the Chapter 9 of the Contract Act, where it creates a relationship of contract. That also is possibly covered with this. Now, this can be a simple vanilla clause where there's an arbitration, this is a basic contract which contains an arbitration clause, and that perhaps covers 99% of the cases where there is a contract between the parties, it contains an arbitration clause. But Lordship will now come to 7.3, 7.2. An arbitration agreement may be in the form of a clause in the contract or in the form of a separate agreement. So you can have a situation where the contract is a mother agreement, so to speak, and a clause is embedded in it. Or you could have a contract, it may have a separate. And I might just add, is whether contractual or not may also impact, like the case of chloro control, how far it extends to parties claiming under them and so on. So though strictly speaking, the other party may not be privy to the contract, but it still may be covered by the arbitration clause. But we are now basically concerned with stamping. Now, kindly come to an arbitration agreement shall be in writing. Now, 4 is important. An arbitration agreement is in writing if it is contained. So it's actually a deeming provision. 7.4 in my humble submission is a deeming provision. It is taken to be in writing in ABC situations. Lordship will just see a document signed by the parties. There is no dispute about that. Now, B and C create problems which are sorted by saying that if there is an arbitration agreement in correspondence, telecommunication, it is deemed to be in writing. Though the word deemed is not used, my humble submission is Parliament has created a legal fiction to say that an arbitration agreement shall be in writing if ABC. If it is contained in a document signed with the parties, an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement, or an exchange of statements of claim and defense in which the existence of an arbitration agreement is alleged by one party and not denied. So even by the rule of non-traverse, I don't deny the allegation.
Actually, the section 7.4 is inartistically worded. What they meant to say was not that it shall be deemed to be in writing, but that there shall be deemed to be an arbitration agreement if A, B, and C are fulfilled.
Yes. That there is an arbitration agreement, though the parties may not simply say that Lordship, see what's the standard clause.
You need not have a contract where both sign the bottom.
And
A sends a letter to B, B responds by email or letter and say, I accept your proposal for an arbitration. It's an arbitration agreement.
yes,
Need not be in a formatted arbitration clause.
yes, like a template clause.
Yes.
It need not be in the template clause which says dispute shall be in arbitration. It will be governed by so-and-so rules.
I propose that all our disputes about price escalation and damages be referred to arbitration. The other party says, yes, I agree, subject to my counterclaims before the arbitrator. It's an arbitration agreement.
And the other issue which doesn't arise arise when stamping is electronic contracts, which I'll come to when I come to stamping. You can't possibly stamp the electronic contracts at the moment. I'll come to that. So my humble submission is, when you say arbitration agreement shall be in writing, now what is the duty of the court under 11(6)(a)? My humble submission is, if the arbitration clause is embedded in the contract itself, then the court does not need to do anything further than say, there is an arbitration clause. That's it. You please go ahead and whatever you want to say it before the arbitrators. But suppose one party says, I've got an arbitration agreement. He files a section, tells the other side, appoint an arbitrator. That party says, no, there is no arbitration agreement at all. Then you may refer to statement of claim, non-opposition, correspondence, telecommunication. That could be a Zoom call which is recorded. You don't know. So then the court will say, yes, there exists an arbitration agreement because of the nature of the correspondence, because of the nature of the telecommunication, correspondence, and so on. And in my humble submission, the role of the court stops there. And Lordship will kindly note that 11(6)(a), Lordship will note contemporaneously, or a bit late 2019 also. When 11(6)(a) was amended, the corresponding provision for international arbitration was section 45. And Lordship will kindly come to 45, where the duty of the court or the jurisdiction of the court is wider. And if the Lordship comes to page 4, section 45, page 1226. Thanks. There, the last part, power of judicial authority to refer to parties in arbitration, parties to arbitration, and notwithstanding anything contained in part 1 or the code of civil procedure. Lordship will note here there is a non obstante clause qua statutes. A judicial authority, when seized of an action in a matter in respect of which parties have made an agreement referred to in section 44, shall at the request of one of the parties or any person claiming through or under him, refer the parties to arbitration. Now this is important. Unless it prima facie finds that the arbitration agreement is null and void, inoperative, and incapable of being performed. And one thing, Lord, prima facie has been brought in 2019. Now, Lordship will note that when the Law Commission report, 246 Law Commission report came, they wanted to restrict the jurisdiction of the court under 11(6)(a) to existence and null and void. The Lordship sees the Law Commission report, that makes it very clear, and it is in paragraph. It comes in para 22 and para 44 of the judgment of NNG 2.
Volume and page.
Yes, volume. Take the page. 3 note starts. Take just 302 at. Yes.
Volume
302.
Volume?
It starts at 302.
Volume 5.
And Lordship will kindly come to para 44, which is at internal page 57, which should be volume page 360, I think.
At page?
Yes, page 360. I'll just take. We'll go to page. Just one second.
360?
Just 1 minute. Let's pardon me. 358 of the PDF page.
Paragraph?
Paragraph 44. Now, my lord, the extract from the Law Commission report, the relevant part is para 33. Lordship, will just read 32. In relation to the nature of intervention, the exposition of the law is to be found in the decision of the Supreme Court in Shinetsu, where the Supreme Court has ruled in favor of looking at the issues / controversy only prima facie. Now, 33 is important and it has been italicized. It is in this context, the Commission has recommended the amendments to Section 8 and 11 of the Arbitration and Conciliation Act 1996. The scope of judicial intervention is only restricted to situations where the court / judicial authority finds that the arbitration agreement does not exist or is null and void. Now, my lord may kindly note, or is null and void is not added in the ultimate law which is made by Parliament. Null and void is there in 45, but null and void is not there in 11(6)(a). My humble submission is, if the Law Commission, sorry, my humble submission is, if Parliament had chosen to put in 11(6)(a) both existence and also null and void, then your lordship's jurisdiction would have been broader. But by deliberately deciding not to add null and void, they have further restricted your lordship the jurisdiction to existence. And this they further emphasize by using the word confine. So now, my lord.
And actually, when they enacted 6A, 6A came by Act 3 of 2016.
Yes.
At that time, in Section 45, the word null and void was already in existence.
It was there. It was.
Except that prima facie came in 2019. So Parliament had before it the provision of Section 45, where the power of the court was, in that sense, extended to determining whether the agreement was null and void. And they didn't follow that formula for domestic arbitration.
Correct. And also Section 8. The lordship sees Section 8. That also was much wider. This is existence of a...
There will be difficulty in accepting that argument.
Pardon me, Lord?
That Section 8, the power of the court is wider compared to Section 11.
No, I'm not saying...
Otherwise, fastest thing it differs, everybody will start filing petitions, civil suits.
No, at the moment, my lord, we are only concerned with 11(6)(a) and Stamp Act.
There is some difficulty in this argument also.
Yes.
Existence something which is null and void cannot exist.
No, my lord.
So there is no. Parliament also, when it enacts, it does keep out redundant words. So won't it be better for you to confine yourself to the issue in question?
11(6)(a). Yes. Only my only submission, which I will come to
relating
later.
to the Stamp Act.
Yes, Stamp Act. Only my submission is, which I'll just elaborate it later if necessary. In a landmark essay called Metaphysics of Nullity, where they say nullity and voidness are de jure concepts. An agreement can exist in fact, but it could be null and void in law. Like a notification which is ultra vires the act exists in fact, but unless it is struck down, it exists in fact, but not in law. But at the moment, I'll take a lordship's hint. I'll straight away go to 11(6)(a). So my submission is, no, I was answering my lord the Chief Justice's question.
No, that's fine.
No, what I'm saying is, when the draftsman sat down and prepared 11(6)(a), where is judicial intervention? What's the role of the courts? It's in Section 11, it's in 8, it's in 9, it's in 14, it's in 34, and so on. So in the case of appointment of arbitrator, you have 11 and 45. 45 has null and void, here they drop null and void. So my submission is, if the agreement is null and void, still, my lord, the court can't go into this question on as far as existence is concerned. Say, no, there's no arbitration agreement at all. It's barred by limitation. I'll come to that. Because howsoever the court may want to be a sentinel on the QE, so to speak, and filter out meaningless arbitrations, nevertheless, my lord, in the interest of the arbitration law itself, the court must confine itself to what Parliament says. Just see the existence of an arbitration agreement. Because 16 talks of validity. Lordship will see section 16 for a moment. The Lordship sees section 16. This is the electronic page.
Yes.
And if you to take a Lordship's thing, 45 is null and void, 16, page 1214.
Which provision are you referring to?
4A, my lord. All 16 is 1214, page 1214.
Arbitration. 121448.
1214.
Yes. Sixteen one
16 one.
at page 1214. And I'll go straight away to the Stamp Act. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement and for that purpose. So, my lord, this is there from day one, from the 1990s, from day one. It gives an hint that the tribunal has to see existence itself. If there's an arbitration existence, then it may have to go to the issue of validity. Because once the arbitration agreement exists, it may become invalid on so many other grounds. But there's an arbitration agreement. So existence and validity are basically two different concepts. S.B. Patel introduced validity at the appointment stage. And that was expressly rejected later. Doctor will find the S.B. Patel was noticed by the NNG1. And there they say that no, we will not. S.B. Patel expressly says that we will go into validity also. The duty of the court is to go into validity. And that is then taken off by the amendment. And that the Lordship will find where there is. No, where is it? Yeah, Lordship will come to 5A page. No, no. I'm talking of in NNG2. Lordship will just bear with me for a minute. Just they refer to S.B. Patel, the extract S.B. Patel. Huh? Para 38. Page 355. Now, my lord, the extract para 12 of SBP and Lordship will just come to above para 39, the italics portion.
Where are you reading, Mr. Datar?
Page 353, it starts para 38.
At volume 5A?
Yes, volume 5. Yes, madam. Yes, madam. And Lordship will just go to the end of the paragraph, which is on the next page, and just above para 39. The italics portion, Lordship has got the italics portion.
353, 354.
My lord has got the italics portion. We are inclined to the view that the decision of the Chief Justice on the issue of jurisdiction and the existence of a valid arbitration agreement would be binding on the parties when the matter goes to the arbitral tribunal and at subsequent stages, except in appeal so and so, so and so. So in this entire paragraph, they say the Chief Justice must
Just
also
one, just
above para 39. Yes, if your lordship wants, come to placetum B, my lord, of the same, in that same page. The question in the context of subsection 7 of section 11 is, what is the scope of the right conferred to rule upon its own jurisdiction? once the Chief Justice, etc. Then they say that at the appointment stage, under 11, the Chief Justice has to go into the jurisdiction and existence of a valid arbitration agreement. And once he decides that it's binding on the arbitral tribunal. Now, my lord, so I'll just say that as far as 11.6a is concerned, in 2015, they have made it absolutely clear that you confine yourself to the existence of an arbitration agreement. Do not go into validity. Now, my lord, one more thing we should note, because whatever your lordship decides will impact the further law, because now they are going to delegate the power to institution. That's a proposal which has not yet been notified. Once an arbitral institution is to go into appoint an arbitrator, then that institution has no jurisdiction to go into the issues of other aspects at all. Right? They will simply appoint and then leave it to the arbitrator to decide.
Mr. Datar, therefore, 11.6a is no longer, it's been 2019 and now
It
abrogated.
has not yet been notified.
It's-
It's not been notified.
They're not been notified because of the institution not being.
Not being, yes, not being.
Otherwise, once the institutions are functional,
Yes, yes. No, I'm saying that all that is part of a scheme.
there's no connect between institutionalization in the
No,
form
what
which
I'm
is now
submitting is,
and the earlier enactment.
no, what I'm submitting is section 11 is the appointment stage, what we call the pre-arbitration stage or the pre-referral stage. Now, since your lordship asked the question, now there are clear distinctions. You can't appoint an arbitrator, therefore the arbitration cannot start. Court intervenes and says, Justice so-and-so or Mr. So-and-so is the arbitrator or the chairperson. You start moving. Then you go to section 16. Before 16, you argue on existence and validity. Now come to 34. I'm saying it's a full scheme. Existence is by the court. Existence and validity is by the arbitral tribunal. And the correctness of the arbitral tribunal on validity is
Then
part of the
second look is
limited
by the
judicial
court.
review under 34.
34.
Yeah, that's right.
So lordship sees 34.2a2. So if you now get into validity, you're really rupturing the entire scheme in my humble submission, because validity is left to the arbitrator. They decide the validity. The arbitral tribunal decision is not final. It's subject to judicial review by a 34 court. The 34 in bracket 111.222. Please come to 34.2a2.
That's fine.
Sorry. So lordship kindly sees the arbitration 34.2a2 arbitration agreement is not valid under the law in which, so that existence is not part of there, only the validity. And I'm just thinking to myself, lordship, I remember our law college days, my lord, we learned that all contracts are agreements, but all agreements are not contracts. That we studied in the law college. So I would say, my lord, use that analogy to say that every valid arbitration agreement exists, but every existing arbitration agreement need not be valid. An arbitration agreement may be there. And I'll come to Mullah's passage, which is quoted in this That's why when I come to contract, I'm going to point out the word void contract is an oxymoron. You can't say that, but I'll come to Stamp Act later. So, my lord, my submission is, I'll conclude my submissions on section 7, 11, 16 and 34 and say that validity has gone into the arbitral tribunal area subject to a check under 34 and of course to an appeal under 37 and 136. Now, my lord, let me come straight to the Stamp Act. How does the, sorry. Yeah. Where is that unenforceable? Yes, sorry. Now, my lord, I'm coming straight away to the Stamp Act. And lordship will come to page 394, volume 5A, which is the NNG2 judgment. And before reading it, my lord, I'll just give a broad overview of what I wanted to submit.
Page 394.
394 of volume 5A. This is the part of the NNG2 majority judgment.
390 volume 5A.
5A. I'm not going to read all the paragraph. I'll just show lordship what the majority has held. And then I'll just come to the conclusion. Yeah, para 97. My apologies. I didn't see.
No, we apologize.
No, my lord, now just, I'll tell Lordship broadly, what is the view taken by the majority? What they say is the Stamp Act is a fiscal enactment. It has got its own importance. It's a source of revenue for the state. And under section 33, when a document is tendered which is not stamped or inadequately stamped, then the judicial authority or the holder of public office
Has to impound it.
has to impound it. Now, my lord, what is important is 33(2). And 33(2) casts a duty to examine, because as a lordship knows, it could not be stamped. It could be inadequately stamped. There could be very many situations. Is it coming under which item of the schedule? What's the quantum of stamp duty? Inadequacy. All these issues are there. That has to be examined in terms of 33(2). And what the majority says is that it is our duty. 11(6)(a) is a duty to examine the existence of an arbitration agreement. 33(2) casts a duty upon us to examine the correctness of the stamp. So both are in different compartments. The fact that my jurisdiction under 11(6)(a) is limited to examination does not mean that I cannot confine my duty to 33(2). And in my humble submission, that is an error of the majority, because Parliament has decided you don't worry about stamping in that sense. You just deal with the existence of an arbitration agreement. Stamping is a matter of validity. Stamping, registration, limitation, all this goes to validity. Let that be decided. But what the majority says is the document is under our watchful gaze. And if we notice that the document is not stamped, then we necessarily have to 33(2). My humble submission is, even if under the watchful gaze you notice it is not stamped, under 11(6)(a), today you're confined to only existence of an arbitration agreement. The statement of objects and reasons stays, you will not deal with other issues. I don't mean to be disrespectful, but I'm just saying in a matter of speaking, what Parliament says is, let the courts confine to existence. All other issues, let it be relegated to the arbitral tribunal. Because ultimately, what is the purpose? The arbitration must be fast-tracked as much as possible. The judicial pit stops must be very, very limited. Under section 11 or 8, very, very limited. Let it go to arbitration, because parties have agreed that my dispute will be resolved by arbitration. And in Great Offshore, your lordship said all these are issues which interminably delay the arbitration proceedings: stamping, registration, validity, limitation. The court need not go into it. But just see the passages. In my humble submission, these require to be overruled, is my respectful submission.
Which is the paragraphs you want us to see?
It starts at...
If you can just give us the paragraphs first, we'll make a note and then quickly breeze through those paragraphs.
Yes, yes. Lordship will just come to para 146. Now, my lord.
Paras which you think are important so that...
So I don't need to read it, my lord. I'll just...
No, we'll read them, but if you can just tell us which...
Yes, para 146 from Placitum D. 146 are the contentions at page 394 of volume 5. Now, para 147 is important. Then, my lord, the final conclusion is at para 150, 151, 152.
Para 146?
146, 147,
150,
the 150, 151, 152.
152.
These are the important paragraphs.
These are the only paras.
The only paragraph.
And what about the minority?
My minority goes into the aspect, both Justice Rastogi and Justice Roy say that, look, it's not our concern to do that at
Can
all.
you give us just the paragraph?
I'll give the paragraph numbers
later.
also. In fact, apart from this, Justice Roy goes into the aspect of section 5 of the Arbitration Act. His lordship compares the unicitral model with section 5. I'm coming to that. So I'll just finish 33.2. Please see 33.2. My lord, can I just read this paragraph first? Sorry, my lord. My lord, para 146 at page 394, my lord, in volume 5. My lord, lordship says the heading starts, section 33, and yes. The court or the arbitrator to act. My humble submission is Lordship will see at page 90, which is page 394. It's subpara alphabet O, and the question the court puts to itself is section 33 and 35 of the Stamp Act, the court or the arbitrator to act. And the court rules that the court has to act. And in my humble submission, that is against the mandate of section 11(6)(a), read with section 5 of the Arbitration Act. And I'll make good my submission in the context of 33(2). May I just read the paragraphs first and then go to the statutory provision? Now, please see para 147. Para 146 is the rival contentions. Now, please come to para 47. We see merit in the contention of the appellant. Apart from the court acting in consonance with the law, when it adheres to section 33 and 35 of the Stamp Act, where it applies, in our view, under the watchful gaze of the court, be it the High Court or the Supreme Court, the issue related to stamp duty in a case where there is no stamp duty paid is best resolved. So this law is that when the court sees that there is no stamp duty paid, it immediately impounds the document and proceeds. Then, my lord, the question would arise as follows. A document containing the arbitration clause may not bear any stamp duty. We have already found that even in an arbitration agreement on its own may require to be stamped as submitted by the learned amicus. But then the court can proceed on the basis that the amount of stamp duty which the arbitration agreement contained an arbitration clause would be exigible to be extremely meager. There is very little likelihood of such an arbitration agreement not being stamped. Therefore, what the court is to consider is when the contract in which the arbitration clause is contained is not duly stamped, when it becomes the duty of the court to act under 33 and 35 of the Stamp Act. Then, my lord, they discuss the background of section 11(6)(a) SMS. I'll skip that with the lordship's permission. Now, 150. The question further arises as to whether, in view of the power of the court under section 11(a) to find only prima facie the existence of the arbitration agreement, it would enable the court to make a reference and appointment and relegate the issue of impounding the document to the arbitrator. In any shirking of the statutory duty by the court under section 11(a) to act in tune with the peremptory authority dictate of the Stamp Act appears to us unjustifiable. Such abdication of its plain duty is neither contemplated by the lawgiver, nor would it be justifiable as causing the breach of section 11(6)(a). Now, 152 is the final conclusion. The view that cases under section 11 would consume more time and hinder the timely progress of arbitration, and that the matter must be postponed so that the arbitrator will be more suitably deal with it, does not appeal to us. While the Stamp Act is primarily intended to collect revenue, and it is not intended to arm a litigant to raise technical pleas, this would hardly furnish justification for the court to ignore the voice of the legislature couched in unambiguous terms. We find that the view expressed in SMSTA states being reiterated despite the insertion of 11(6)(a) would promote the object of the Stamp Act and yet be reconcilable with the mandate of section 11(6)(a). We may, however, qualify what we have said with a caveat. There may be cases where no stamp duty has been paid. paves the way for the unambiguous discharge of the duty under 33 and 35 of the Stamp Act. There may be, however, cases where it may be stamped, but the objection is taken by the party that it is not duly stamped. In such cases, no doubt it is ordinarily the duty of the court to examine the matter with reference to the duty under section 33(2). If the claim that is insufficiently stamped appears to the court to be on the face of it wholly without foundation, it may make reference on the basis of existence of an arbitration agreement. Otherwise, and then leave it open to the arbitrator to exercise the power under section 33 should it become necessary. This approach just does justice to the word examine in 33(2) of the Stamp Act, while not ignoring the command of section 11(6)(a) of the Act. It is not to be confused with the duty to examine prima facie whether an arbitration agreement exists under section 11(6)(a), but is related to the duty to examine the matter under section 33(2) of the Stamp Act. Now, this particular passage says the court has two duties. 11(6)(a) is existence, 33(2) is stamp. And my power under 11(6)(a) does not take away my duty under 33(2). And my humble submission is that is in the teeth of section 5 of the Arbitration Act. Now, please see 33(2) and please see section 5. Kindly come to 33(2) of the Stamp Act, volume 4A. The Stamp Act starts at page 324 and 33 is at page 357. And if I may read that. Yes. Please come to page 357, volume 4A. Lordship has got 33(1). May I read now 33(1) and 33(2).
Yes.
Then I'll come to section 5 of the arbitration. Every person having by law or consent of parties authority to receive evidence, and every person in charge of a public office, except an officer of police, before whom any instrument chargeable in his opinion with duty is produced or comes in the performance of its function, shall, if it appears to him that such instrument is not duly stamped, impound the same. Therefore, my lord, the jurisdiction is conferred upon authorities who can receive evidence and office people who are holding public office. He shall impound the same. Now 33(2) is important. For that purpose, every such person shall examine every instrument so chargeable and so produced or coming before him in order to ascertain whether it is stamped with a stamp duty of the value and description required by the law in force in India when such instrument was executed or first executed. Now 33(2) is a very wide duty. You have to examine what? Examine whether it is of the proper value, valuation, description, which is classification. Is it a license? Is it a lease? Is it a bottom bond? Lord, we had a lot of controversy, mortgage, whether it's a, what you call mortgage, a conditional mortgage, different types of mortgage. What is the stamp duty? Lease license is a common problem. So you have to examine whether it's a value and the description required by a law when such instrument was executed or so and so. And not provided, all these things are there, which says that nothing contained shall deem to require a magistrate to examine or impound if it does not so think fit an instrument. But on the limited point of 33(2), I'm submitting that the word 33 includes the verb examine. The impounding under 33(1) has to be done after examination under 33(2). So 33(2) comes first. You prima facie see there's a document, it's not stamped. Then you exercise powers under 33(2). And then you. Now, please come to section 5 of the, yes, of the Arbitration Act, which 1207 in volume 4A. And in that context, my lord, I would rather your lordship sees the minority judgment of Justice Roy, where his lordship extracts section 5 of the UNCITRAL model, section 5 of the act, so everything will come in one place. Please come to para 341 of the NNG2 decision. Para 341.
Page number?
Page, I'll just page, just one second. Get that electronic page. 455, yes, 455. Of volume 5A. I'll start with 341.
455.
Lordship has got, 341, 342. Have all your lordships got 341 of minority view of Justice Roy? Very important. Further, on reading Article 5 of the Model Law and Section 5 of the Arbitration Act 1996, which cover the provisions for judicial intervention in arbitral proceedings, it is clear that Parliament went beyond Article 5 of the UNCITRAL Model Law and added a non obstante clause. To substantiate this point, it is pertinent to quote the provisions in full. Article 5 of the UNCITRAL Model Law reads as under: extent of court intervention. In matters governed by this law, no court shall intervene except when so provided in this law. Now please come to 5, extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part, which is part 1.
So the of a non-obstante clause covering statute law in 11.6a
Yes.
is really dealt with by this omnibus non-obstante clause in section
Yes.
5.
No, I'm grateful. I'm just putting for your lordship's kind consideration a further point. Now, my lord, 33.2 was already there when the Arbitration Act 96 came in.
Right.
There is an examination on the correctness of stamp duty. There is no doubt that your lordship exercising powers under 11.6a is an authority which can receive evidence. My humble submission is 5 must be read with section 11.6a, and when so read, it will prevail over 33.2 because these judicial intervention powers of the Supreme Court and the High Court intervention will only be to the extent provided in part 1. Because it says so provided. And the word so provided means only existence of arbitration agreement. And the word examine is used in 11.6a, examine is used in 33.2. There are 2 types of examinations. And the Stamp Act examination is expressly excluded, is my humble submission. Lordship may kindly consider. Now, my lord, well, lordship is on this. Lordship will now come to an interesting paragraph. Now I'm now coming to I'm now going into the realm of
the majority deal with section 5?
Pardon me?
How does the majority deal with section 5 in NG2?
No, they just extracted, but
they don't.
So subject to correction only Justice Roy deals with the UNCITRAL model. Para 120.
Let's just see that.
Yes.
PDF page?
388.
Let's see that right away.
Yes, I'm grateful. Para 8. May I read not para 1? Sorry, I missed this. Section 5 no doubt provides for a non-obstante clause. It provides against judicial interference except as provided in the Act. The non-obstante clause purports to proclaim, so despite the presence of any law which may provide for interference otherwise, however, this does not mean that the operation of the Stamp Act, in particular 33 and 35, would not have any play we are of the clear view that the purport of 5 is not to take away the effect of 33 and 35 of the Stamp Act. And my lord, in my humble submission, where the majority erred is 33 and 35 is not given a go by. It will be taken up by the arbitral tribunal.
And the object was to really therefore constitute part 1 as a code in itself.
Yes, 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 absolutely. And I'm going to come to further 35 and 36.
The limits, at least insofar as judicial intervention is concerned, the limits of intervention were intended to be exhaustively specified within the ambit of part 1.
Yes. Otherwise, what you're doing is actually with such a barrier is posed, we're putting a coach and 4 through that barrier. We're saying, no. I got 11.6a powers, but my power under 33.2 also continue. I'm saying both can't continue. And the idea is, it's not that revenue will be lost or things will go. This will come before the arbitral tribunal. And Lordship will further come to section 35 of the Stamp Act and 36. Suppose in the course of arbitration, I tender an agreement and the other side doesn't raise an objection to stamping.
Really, stamping has nothing to do with validity as such.
Sorry,
Stamping
nothing
is-
to do with validity.
It deals with admissibility.
Admissibility.
It's taxability and
The agreement,
and enforceability.
an unstamped agreement is not invalid. It cannot be
Enforced.
admissible in evidence. That's
It
all,
can't
and
be-
therefore cannot be cited as an
Yes,
exhibit.
Lordship, it'll affect its enforceability.
That's
You're
a
right.
specific provision, right, in
Yes.
the Stamp Act.
Yes, and I will also point out,
So the issue is,
That's right.
really issue is where will it be debated? Is
Yes.
it debated before?
which forum?
Is it debated before the arbitration? It's a
Right.
forum issue.
Yes. So it's not that, if the court ignores it, it is going to escape. And I'm going to make one further submission. So my
35 is very clear. That 35 says it will not be admissible in evidence. That's
evidence,
all.
yes, but you please see section 36 of the arbitration, of the
Mr.
Stamp Act.
Datar, that's the reason when you're going repeatedly on validity, I didn't want to interrupt you because it's not really, Stamp Act has got nothing to do with validity.
Exactly. No, but what will happen is I'm going to come to that. When I come, there's a very good passage extracted by the majority from Mullah, but I'll come. Please come to 36. What's this 36
36 of Stamp Act.
of the Stamp Act? That will be page 358, I think. 36. 358. 360 top.
That is, once it is admitted in evidence, it is not, cannot be called.
Yes,
question.
so that's going to be because the majority says an agreement not stamped is non-est in law, which I'm going to come to later on contract. It's bereft of existence. That may not be a correct proposition.
Obliterated, isn't it?
So, my lord, if an agreement, and that's what Jhaverchand says.
Curable on payment of penalty.
My lord, I was going to say one thing. I sign an agreement. I don't stamp it. Now I run the risk if I don't stamp it under section 17 stage at execution stage. Tomorrow, if I want to enforce it, I have to pay 10 times the duty. So I take the risk. I know many cases where the arbitration clause is contained on the back of a bill or it's contained in some letter. Number of contracts take place between multiple parties. I don't want to go every time to the stamp, get a non-judicial stamp, get 100 rupees, witness, etc. I don't need it. I got an agreement. I got a very agreement. And again, the difficulty of the majority judgment is, suppose you say that I was an arbitration clause, it's not denied. How do you stamp that? It's in a telecommunication, electronic record. Now the amendments have been made that electronic record is a document and so on. Sorry. Then come last two.
the issue where we are told that now, on the basis of NNG2, all existing arbitrations and objections being raised, that, well,
Yes.
how could this
I'm
be?
coming to that because it's honest in law, not existing.
36 is a clear answer that once the document is marked in evidence, then the instrument cannot be questioned on the ground of insufficient stamping.
Yes. That's why in Jhaverchand, the Supreme Court points out that the party has to be vigilant. If it does not take the objection at that stage and allow the document to be marked, may not be normal P1, P7 or whatever it is, then once it's marked as an exhibit, you can't at the argument, because it says at any stage of the proceeding, you can't then say that, look, it's not stamped, you should not have acted upon it. So, my lord, so my humble submission is, to conclude my submissions, 33.2, examination qua stamping.
Just, can we just formulate it?
Yes.
P.Datar?
My humble submission is, the majority judgment on this duty of the court to impound the document is incorrect because the majority did not notice Section 5, did not consider Section 5 of the Arbitration Conciliation Act.
Say we did not apply Section 5.
Apply Section 5.
Because they noticed it.
Correct, correct. They noticed. I'm sorry, my apologies. They did not apply Section 5. In fact, they say Section 5 doesn't overtake my duty under 33.2. So my submission is, because of Section 5 read with Section 11A, the judicial intervention, so it contemplates that the court notices there is a flaw, there is a defect. But the court says don't intervene because it now must go to the arbitral tribunal where all these issues will be dealt with. So once judicial intervention is confined to existence of an arbitration agreement, the jurisdiction to examine stamping under 33.2 is taken away when court exercise powers under 11.6a. That's all. And with that, I'll come to Contract Act. Now, my lord, the more than Stamp Act, the difficulty in the NNG judgment is to say that if an agreement is not stamped, it is bereft of existence, it is void, and the majority says voidness and enforceability are conflated out together, which I'm humbly submit is may not be a correct interpretation of the Contract Act, because Lordship kindly sees they take 2G and 2H of the Contract Act. I'll come to the definitions. And then they say that if an agreement is not stamped, it is void. In my humble submission, if an agreement is not stamped, it is not void. It's a curable defect because you say an agreement, so I'll have to see 2G, 2H, Section 10 and Section 23 of the Contract Act. Yes. And Lord, while on and 28 also. They say it's non-enforceable. Permission, I'll read the statutory provision and then I'll try to submit that the judgment may not be in consonance with what is the statutory provision on contract law. Now, what they basically say is if an agreement is not stamped, it is not a contract. It's not an enforceable contract. And I'll show to your lordship that it is not, in my humble submission, not the correct view.
But that's
because
directly contrary to the statute itself.
That's my submission.
Statute merely makes it inadmissible in evidence.
That's all. That's all. And what it
It's a
says,
statute for the collection of revenue. So the cloud on the document, on its admissibility, not on the document or the transaction, the cloud on its admissibility is lifted by the payment of revenue and the penalty for not having paid it in the first place.
Lord, our concern is apart, as the lordship put it, apart from at various stages, this point is being raised and everything has come to a standstill. Sorry, my lord. Yes.
Should you not fortify your last argument of agreement being void, relying on Hindustan Steel, para 6 and 7?
Yes.
Just kindly read it.
Hindustan Steel, Dilip Construction.
Correct.
Yes.
Kindly read two paragraphs, 6 and 7 respectively.
Of Hindustan Steel.
That's at page 588. What has just fallen from my Lord the Chief Justice. Apropos what you argued the last.
Yes.
Before you take over Contract Act,
Yeah,
the last part.
I am grateful.
Jamshid,
Yes.
para 5, volume 5 page.
Yes. At page 588. my lord.
588. It's a 3-judge bench decision.
Hindustan Steel is actually 1969 1 SCC
Correct,
597
Correct.
at 600.
Correct. And it's a part of your paper book.
Yes, it is. Yes. May I read, my lord? Para 6 and 7. I'll read para 5, my lord.
Yes.
May I read, my lord? Page 588, volume 5. An instrument which is not duly stamped cannot be received in evidence by any person who has authority to receive evidence, and it cannot be acted upon by that person or by any public officer. Section 35 provides that the admissibility of an instrument once admitted in evidence shall not, except in section 61, be called in question at any stage of the same or proceeding on the ground that the instrument has not been duly stamped. Relying on the difference in the phraseology between 35 and 36, it was urged that an instrument which is not duly stamped may be admitted in evidence on payment of duty and penalty, but it cannot be acted upon because 35 operates as a bar to the admission in evidence of the instrument not duly stamped, as well as to be acted upon. And the legislature, by section 36, in the conditions set out therein, removed the bar only against admission in evidence of the instrument. The argument ignores the true import of 36. By that section, an instrument once admitted in evidence shall not be called in question at any stage of the same suit or proceeding on the ground that it has not been duly stamped. Section 36 does not provide a challenge, does not prohibit a challenge against an instrument that it shall not be acted upon because it is not duly stamped. But on that account, there is no bar against an instrument not being duly stamped being acted upon after payment of stamp duty and penalty according to the procedure prescribed by the Act. The doubt is, if any, is removed by the terms of 42, which enact in terms unmistakable that every instrument endorsed by the collector under 42(1) shall be admissible in evidence and may be acted upon if it is duly stamped. 7, I'll read, Manoj. The Stamp Act is a fiscal measure.
It's more important.
Yeah, yes, ma'am. To enact, to secure revenue for the state on certain issues, on certain classes of instruments. It is not enacted to arm a litigant with a weapon of technicality to meet the case of his opponent. The stringent provisions of the Act are conceived in the interests of the revenue. Once that object is secured according to law, the party staking his claim on the instrument will not be defeated on the ground of the initial defect in the instrument. Viewed in that light, the scheme is clear. Section 35 of the Stamp Act operates as a bar to an unstamped instrument being admitted in evidence or being acted upon. Section 40 provides the procedure for the instruments being impounded. 42(1) provides for certifying that an instrument is duly stamped, and 42(2) enacts the consequences resulting from such. Then what they go?
Allahabad High Court to the contrary.
Yes.
As an aside, Justice M.C. Desai, whose judgment is overruled,
Yes.
was one of those last few ICS judges in the Indian judiciary. But Justice
Yes.
Manoj Mishra will confirm, I think he was an ICS judge in those days.
And I think Allahabad had a English judge, Justice Broom, who was there well after independence. He continued till almost 73, 74. Falshaw was in Punjab. Most of the English judges left, but continued. Yes. Now, my lord, my submission is this. Yes. And Lordship will take page 369 of a majority. They doubt. To answer Justice Pardiwala's question, NN Global majority doubts Hindustan Steel at para 69. Lordship will come to page 368. 368, volume 5. Volume 5A, page 368. Para 69 at page 368 of volume 5, my lord. 5A. Yes, my lord, in the light of what Justice Pardiwala asked Hindustan Steel, there is a slight doubt expressed on Hindustan Steel in the majority judgment of NNG2, which is at page 368, para 69. So they don't expressly say it's bad law. Para 69, at the bottom of volume 5A, page 368. May I read?
See, here also the power of impounding
Yes.
is only when it is produced before an authority.
Correct.
It's not, if you keep it with yourself, there is no impounding.
But
There's neither any proceedings under 31, 33, etc., don't apply. 33, etc. will
I'll
not.
just give an example. When I was a junior and I had a lot of work in the city civil court, and there was a particular well-known company which had a number of agreements with agents, 400, 500 agents. And out of 400, 500, 10 or 15 will default. And they were very, very keen on litigation. They would not spare anybody. So they would file suits. And only in those recalcitrant agents, they'll pay 10% the stamp duty. And the proprietor told me, why should I spend money on every agreement? Everybody is not going to default. Whenever a party defaults, that alone I'll pay 10 times the stamp duty. And it's a commercial call. Why not? Because 99 agents will comply with the law. The one person who don't comply, stamp it. I'm also thinking to myself, what about electronic contracts? Now they are also taken as document. You simply say, I agree, click, crack, shrimp. There's a dispute. I suppose, I don't know how it's going to test it. In those cases where there's a dispute, you take a printout, stamp it. And what the what the majority finds fault is that they've not taken note of section 17, which is the taxable event. But Lordship knows in tax, there is always a difference between taxable event and the actual payment. Here what they say is, you take a risk. You either pay the stamp duty at the section 17 stage. If you miss the bus, or if you take a calculated risk of not paying at the section 17 stage, then when you come to 35, 42, etc., you'll pay 10 times the amount with the penalty. And there's also penalty under 62, which says that whatever extra you pay will be adjusted against the penalty. So my only submission is, as my lord slightly pointed out, this will not make the instrument, it's not fatal to the instrument. The arbitration agreement exists, the contract exists, it only remains unenforceable. So my lord, these passages may require to be overruled is my humble submission. Shall I take the section first and then the passage, or the passage first and then the section?
Section first.
Section first. Please come to the Contract Act.
The contract have been.
Yes, Lord, and one more thing I'll mention. One other argument I'm going to take, but Mr. Sakharan elaborated. My view, my humble view is that arbitration agreement, because Stamp Act uses the word Article 5 says agreement. Can it include an arbitration agreement? There's a serious doubt because there's a residuary clause, agreements not elsewhere specified. But all these require instruments. Now, one argument which he'll develop is that arbitration agreement need not be stamped in terms of the Stamp Act. That he will elaborate further.
We didn't need to go into that here at all.
No, I just leave it to Lordship, yeah. No, because NN Global holds. Lord, in para 90, sorry.
Yeah?
In para 90, no, just to answer Lordship question, which Ms. Sakharan will deal with. In para 90, they formulate the question and say, is an arbitration agreement liable to be stamped? And in fact, in my curative also, what's happened is it's an agreement to lease. If an arbitration agreement is contained in the larger contract, suppose the main contract stamping is 1,000, but it's only an agreement to sell, not a sale per se, and there's an arbitration agreement. Suppose I put it as 100 rupees. Some cases they have put arbitration agreement stamp. Here, agreement is mentioned in Article 5, and the last says, like a residuary clause, agreements not elsewhere specified. But the nature of 7.1, 7.2, 7.3 shows that arbitration agreement has not been included in the, for example, in the case of award, Supreme Court has said award doesn't include a foreign award for Stamp Act purposes. So maybe agreement that Lordship, he will consider, Lordship may decide whether to take it up or not later. So I'll straight away come to the Contract Act. Now, my Lord, what is the role of the contract?
We are really on the narrow issue as to
11.6.
what is the stage at which a dispute about stamping has to be decided. Does it arise at the stage of 11.6?
Yes.
Whether an arbitration agreement should or should not be stamped ultimately, and we don't have the states here before us. So
yes, and my humble submission is the Contract Act, in para 152, the majority makes a division. If it is absolutely without foundation, they can step in. If it is partly without foundation, it has to be left to the arbitrator. But on my humble submission, that creates a lot of uncertainty in the law.
that's where they say if it is not absolutely unstamped,
Yes,
insufficiently stamped, then send it to the arbitrator.
send it to the arbitrator.
If you find that there is no foundation, prima facie no foundation in the objection to stamp.
My humble submission is
that distinction.
Yeah, that's the distinction. I'm saying that should not be made because
This is accepted.
majority says 152.
There's a curable
Lord, as Mr. Mehta rightly points out, please come to page para 166. Para 152, they say sufficiently stamped, insufficient, but para 166 and 167 are clear.
Which
If it is
page?
not, page 399. These are the two observations which Lordship will see 166, 167. All your Lordships have got it
At page?
at page 399, volume 5A. Yes. An arbitration agreement within the meaning of section 7 of the Act, which attracts stamp duty and which is not stamped or insufficiently stamped, cannot be acted upon. In view of section 35 of the Stamp Act, unless following impounding and payment of the requisite duty, necessary certificate is provided under section 42 of the Act. So, my lord, they say at 11.6a you stop.
Where do they deal with section 36?
Next, they don't deal with section 36. Please, is subject correction. They note it, yes.
But they don't deal with it.
Yes, I'm coming to that, exactly coming to 36, next paragraph. We further hold that the provisions of 33 and the bar under 35 applicable to instruments chargeable to stamp duty under section 3 read with schedule would render the arbitration agreement contained in such instrument as being non-existent law unless the instrument is validated under the Stamp Act.
Now therefore,
This is completely in the teeth of 36. If the agreement is non-existent in law, it can't even be, it can't, 36 what it says is, if you don't take the objection to stamping, you can't question it later. You can't say it's not existing in law, sorry. Yes. And to your answer also, para 108, they discuss section
381 lot, page 381, volume 5A, paragraph 108, going over the page of 382. Three 81 lot, 108 paragraph.
but it spills over to 182, yeah.
It's over the
Equally, placetum A. What you seen that one? So, my lord, my humble submission is both para 166 and 167. In my humble submission, do not represent the correct position of law. And the correct proposition should be that if the agreement, first of all, under 11.6a, you do not need to look into the Stamp Act at
Last
all.
sentence of paragraph 108,
Yes,
just read that.
it is not invalid or void.
What, start from one sentence above that.
Sorry.
Thus an unstamped or insufficient text.
Yes, yes. Placetum B. Now, I'll just read further, equally under section 36. That's better. My Lord Justice Khanna asked me to has drawn the attention, para 108 at page 381. All your lordships may kindly come to page 382, placetum A, my lord. Equally, may I read, my lord? Equally, the third line, under section 36, in the case of an instrument, not secondary evidence of the instrument, which is allowed to be let in evidence without objection, then it would qualify as evidence founding a right. But this is an exception to the rule found in section 35 of the Stamp Act. Thus, an unstamped or insufficiently stamped instrument representing a case of an agreement which is not being enforceable, in the sense that the sanctions in law through a civil action is impermissible. In the said sense, invalid. It is not invalid or void in the sense of it being stillborn or null and void, or in the sense that life cannot be poured into it. Now, while they say this, I'll show other paragraph where they say, once an agreement is not stamped, it is completely void, it is bereft in law. Now, since your lordship is seeing that, my lord, I'll just, with the court's permission, go to the other paragraphs. Please come to para 103. I'll just take a lordship through 103 and then 109. Lordship will just come to 103, my lord, on stamping. No, 102, I'm coming last. Mullah, no? Yeah. May I read 103, my lord, at page 380. May I read, my lord? We would find that an agreement which is unenforceable on account of a substantive law, which would include the Stamp Act, would not be a contract. Section applying section 2H of the Contract Act, it is only if the agreement is enforceable that it would become a contract. It is only a contract which would be the arbitration agreement which is contemplated in section 11(6)(a) of the Act. It may not be apposite to merely describe an unstamped arbitration agreement as a curable defect. As long as it remains an unstamped instrument, it cannot be taken notice of for any purpose as contemplated in section 35 of the Stamp Act. It remains unenforceable. Section 17 declares the time at which instrument is executed in India must be stamped. The said provision contemplates that stamping of such an instrument must take place before or at the time of execution of the document. No public officer, nor court, nor arbitrator can permit any person to ask them to act upon it or receive it as evidence. In law, it is bereft of life. It is not unenforceable in law. It is not enforceable in law. In the said sense, it also cannot exist in law. It would be void. Our view in this regard is that voidness is conflated with unenforceability receives fortification from 2J of the Contract Act, which renders a contract which ceases to be enforceable void. What section 11(6)(a) contemplates is a contract and is not an agreement which can be treated as a contract. Number one, they go further. When they use the word arbitration agreement, the court says it is a contract. This is despite the use of the word arbitration agreement in 11(6)(a). In other words, contract must conform to section 7 of the Act. It must also, needless to say, fulfill the requirements of Contract Act. Then Lordship will come to 109. 382. We may sum up. An agreement which is unstamped or insufficiently stamped is not enforceable as long as it remains in the said condition. Such an instrument would be void as being not enforceable. See 2G. It would not in the said sense exist in law. It can be validated by only the process contemplated in section 33 and other provisions of Stamp Act. We find the expression validation used in the decision of the court in Hariom Agarwal, which we shall refer to in greater detail later. This necessarily means that the court would not view it as unenforceable, as enforceable, and therefore existing in law. In the sense explained, it would not be found as not void and therefore not invalid. Thus, in the context of the Act, the Stamp Act and the Contract Act, we have the view that the opinion of the court in SMS estates regarded in Garware and so is correct. Then para 110 is important. 11(6)(a).
In fact, a few days before the judgment was pronounced in this case,
Your Lordship has clarified that
P.Datar doesn't deal with that issue.
Career Institute.
I don't remember the name.
Career Institute. But actually, Lordship never went into the Stamp Act. The opening question itself is very clear, my Lord. Now, my Lord, please see para 110. 11(6)(a) cannot be understood as merely predicating for an arbitration agreement existing literally. This means that the mere existence of an arbitration agreement for all intents and purposes on the exterior, purporting to project a contract duly executed, may in certain situations be insufficient under section 11. If for the reasons such as it being unstamped, when it is clearly required to be stamped, then it cannot be said to be a case where the arbitration exists, or it would be no existence in law. While we agree, the court must be careful in selecting contracts where an arbitration agreement which is produced is not to be acted upon, for the reason it does not exist in law. All we hold is that an arbitration agreement which is not unstamped does not exist, and an unstamped contract containing an arbitration agreement would not exist as it has no existence in law. Now that is contrary to the Stamp Act and also contrary to the Contract Act. And I'll take your Lordship now to the provisions. But before that, since your Lordship is having this thing, the page, please see the excellent passage of Mullah at page 102. Para 102 at page 380. Para 102. Pertinently, my Lord, may I see? May I read? Para 102 at page 380. Pertinently, we may, in the 14th edition of the Indian Contract Act and Specific Relief Act by Pollock and Mullah, note as follows: unenforceable contracts. unenforceable contracts are valid in all respects. Very important. Unenforceable contracts are valid in all respects, but may not be sued upon by the parties. Enforceability is linked. When do you say a contract has to be enforced? When one party does not perform as part of its obligation, you have to get it enforced. Who will be the agency to enforce? Under our system, the judiciary's job is to enforce it. It says that, but may not be sued upon. So if a contract or an agreement is not stamped, it cannot be sued upon, that's all. But it is valid in all respects. Please see further. Such disability may arise for want of registration, or because the time prescribed for filing the suit has expired, or because the plaintiff firm has not been registered, that's section 69, or the document or instrument does not bear the requisite stamp duty, or because the lender of money does not possess a license under money lending laws. Now, Lordship will kindly see what has been held by the learned authors is the correct position. And in my humble submission, what is said in para 103 and 109 is contrary to these positions of contract law. And now let us go to the sections and I'll conclude. Lord, we have to get the legal concepts of what is void, what is unenforceable, very clear, my Lord. And that's why from law college, we have taught that you cannot use the word void contract. It's an oxymoron. A contract may become void because of supervening circumstances. It's only a void agreement. And please come to section 2G, 2H, section 10 and section 23.
2G.
Lordship will come to the definition of Contract Act. 281, one second. Contract Act is 281, volume 4A. May I read, Lord?
Yes.
Your Lordship must first come to 2E. Every promise and every set of promises forming the consideration for each other is an agreement. Then come to 2F. Promises which form the consideration or part of each other, reciprocal promises. Now 2G and 2H are critical. An agreement not enforceable by law is said to be void. An agreement enforceable by law is a contract. Now, Lordship has to see 2H and go straight away to section 10 and 23. Those agreements which don't satisfy section 10 and section 23 come under 2G, which are not enforceable by law. I'll repeat, my Lord. 2H must be read with 10 and 23.
And those agreements, you said?
Those agreements which don't satisfy the parameters of 10 and 23 will be agreements not enforceable by law and which are void. Now please come to section 10. This is the origin of the phrase that all contracts are agreements, but all agreements are not contracts. Now please see section 10. What agreements are contracts? See the marginal note. What agreements are contracts? All agreements are contracts if they are made by free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force in India and not hereby expressly repealed by which any contract is required to be made in writing or in the presence of witnesses or any law relating. Lordship will just note in margin, this nothing is refers to section 25 of the Contract Act. promise to pay a time-barred debt, agreement, I'll come to 25. I'll just finish the sequence. Now, please come to section 10. So section 10 basically says free consent. And when is consent not free? Then your lordship goes to 15, 16, 17, 18 of the Contract Act. 15 is coercion, 16 is undue influence, 17 is fraud, 18 is misrepresentation. If consent is vitiated by these four factors, it becomes voidable at the option of the aggrieved party. So consent is free. Parties competent to contract, majority, there must be a majority age. Then if it's a company, it cannot be ultra vires, the objects clause. For a lawful consideration, lawful object, that takes us to section 23. And I just mentioned not expressly declared to be void.
Not hereby expressed.
Expressly hereby.
Hereby means in this act.
In this act, yes. Now, lordship will kindly come to section 23, which is at page 286. May I read, my lord? 23. What consideration? The consideration or object of an agreement is lawful unless it is forbidden by law, is of such a nature if permitted would defeat the provisions of any law, is fraudulent, involves or implies injury to any person, property of another, or the court regards as immoral or opposed to public policy. In each of these cases, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. And my humble submission, stamp is never the object or consideration of an agreement. Stamp is an incidental part. But object is what we call parties are ad idem. Consideration is in 2D of the Contract Act. When at the desire of a promisor, the promisee, etc., that follows. So my humble submission is, now taking the Contract Act with the Stamp Act, reading 2G with 10 and 23, even if an instrument is not stamped, it is not void under the provisions of the Contract Act, but it becomes unenforceable in view of the Stamp Act. Yes, as my friend points out, it is not even avoidable. Now, Lordship will kindly come 24 just to complete what they say. If any part of a single consideration for one or more objects or any one part of several considerations, single object unlawful, the agreement is void. So you can't apply severability there. It's like the one drop of poison which spoils the milk. Now come to section 28. At page 288. Explanation, exception 1. I read 28A. Every agreement by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by the usual legal proceedings in the ordinary tribunals, or which limits the time within which he may thus enforce his right, or which extinguishes the rights of any party thereto, or discharges any party from enforcing liability under or in respect of any contract on the expiry of a specified period, so as to restrict any party from enforcing his right, is void to that extent. So basically, my lord, if you say you shall not approach the court, or you can't approach the court after a particular period, then that is void. Exception 1 is important. And 2. This section shall not render illegal a contract by which two or more persons agree that any dispute which may arise between them in respect of any subject or class of subjects shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable in respect of the dispute so referred. Exception 2. Nor shall this section render illegal any contract in writing by which two or more persons agree to refer to arbitration any question between them which has already arisen, or affect any provision of any law in force for the time being as references to arbitration. Now, Lordship will kindly note, very, very important, the agreement between two parties that they shall refer the dispute is a contract. 28 does not require that that contract should be stamped. It can be oral.
Yes.
Now come to 2G, an agreement not enforceable by law is said to be void.
So stamping really is not part of
This
this.
is not part of my humble submission. And most important, section 23, because the court says if you don't stamp, it's not existing in law. No. And I'm submitting that the existence of an agreement has nothing to do with voidness. An agreement may exist. All that happens is it's unenforceable. For what the majority in my humble submission heard is, they say that which is not stamped is void and unenforceable. They say that both voidness and enforceability are synonymous. What para 108 says, your Lordship kindly comes. Para 103, our view in this regard that voidness is conflated with unenforceability receives fortification at page 103 in italics. 380, that's very important. But because this goes far beyond the realm of stamp law. A bench of 5 judges, when it holds this, it affects every other agreement, even beyond the Stamp Act. They'll say, look, this is Article 141. If you don't stamp it, it is void. And it may not be, I may not be only bothered about the arbitration. I cannot enforce it in a proper civil court also. We are concerned with arbitration. What they say is my agreement is not stamped, it is void. And one more thing, my lord, there is an inherent contradiction. There is no question of resurrection. What they say, if it is void, then where is the question of it springing back to life after stamp duty is paid?
Then it's still born.
It's still born. It's gone. It's not like the doctrine of eclipse.
I was just going to say, Ambikam is just K.K.
Ambikam
Matthews.
Yes, Bikaji Narayan Dakras, that once the eclipse is removed, it assumes force proprio vigore. All that is not there. There's no resurrection. So, my lord, the proper test of the law will be this. I'll summarize my proposition to say that the Contract Act, the validity of a contract is independent of the requirement of any stamping. As Mullah says, even an unstamped contract is valid in all respects, but you can't sue upon it. Then, Lord, the last point I'd like to make is that on this question of original and certified copy, para 137, 141.3 and 144.
Page number?
Page number is page 130, para 132 is 388.
37 is page 388.
Yes. 391.
Yes.
It starts at 132. Lord, the heading is interesting at page 87. Amicus brings a surprise. That is Mr. Banerjee.
Para 137. 131.
I don't know what he's going to do in this bench, Lord.
A sudden googly bolt by Mr. Banerjee.
Yes. Now, my lord, my humble submission is at page 131, para 131, at page 388. I'll read, Lord. This court pointed out the existence of the scheme prepared by the Supreme Court in exercise of powers under 111.10, para 2A of the scheme inter alia reads as follows. Submission of request. The request of the Chief Justice under subsection 4 or subsection 5 or subsection 6 shall be made in writing and shall be accompanied by the original arbitration agreement or a duly certified copy thereof. Thereafter, when the curtains were about to be rung down by the hearing, the learned amicus brought the following aspect to the notice of the court. He pointed out that under the scheme, the applicant need produce only the certified copy of the arbitration agreement. He would draw support from the judgments of Jupudi Keshavarao versus Pulavarti Venkata Subbarao and Hariom Agarwal to contend that even applying section 33 and 35 by the court at the stage of section 11, the certified copy cannot be impounded. He thus sought to take the wind out of the sail of the appellant's contention by contending that in most of the cases, since certified copies alone are being filed and they cannot be impounded, and as reference to the arbitrator based on certified copy, the arbitrator is competent under section 33 and 35 to do the needful. This court may bear this aspect in mind. Thereupon, Shri Gagan Sanghi would point out that even in the certified copy, the factum of payment must be entered. This satisfactory. No matter, my humble submission is, please come to para 137. Yes. 391. I'll read 137 and 141.3. The submission appears to be that the scheme provides for a certified copy of the arbitration agreement if the arbitration agreement is part of the contract, which is either not stamped or insufficiently stamped. And since it cannot be impounded under section 33, cannot be validated, all that the court has to look into is whether the arbitration agreement exists. What it means is whether the arbitration agreement duly stamped exists, what that ultimately mean, though they don't say so in some ways. Then 141 is the interplay of evidence, para 141, interplay of Evidence Act, Stamp Act, Registration Act, and then they conclude this. But my submission is this: as far as certified copy is concerned, this Supreme Court scheme is pre-2015. After 2015, when I make an application under section 11(6)(a), that is, rules can't be contrary to the Act, my humble submission is the registry will be bound to receive the application because the court's jurisdiction is only to see the existence of the arbitration agreement. So there's no, and suppose it's exchange of letters. Suppose it, of course, letter also the proviso says any one letter can be stamped. But suppose it is electronic, telecommunications. What do you do? So that
after 2015, you said when the application under section 11(6)(a)
is filed,
the registry,
there's no need to produce the original or certified copy.
yes,
I can just file a copy, any copy. It need not be certified.
So
It can be a true copy.
Mr. Datar, what you're propounding then is that only amendments in the petition should be made.
With a copy of the agreement if it is there. Or suppose, if its agreement is there. Sorry.
The reason why they don't ask for the original is because it may be with the other side.
With the bank or something else.
Obviously, to certified copy has always been, whether it's High Court, it's been always, that does not say certified copy or anything like that. So it leaves it as a matter of procedure. So this is the reason why the rules, several high courts also, the rules provide, you have to give the certified copy.
Many high courts don't provide that also.
They
Delhi
may
High
not-
Court, but in fact.
No, we have been insisting in Delhi High Court also. That when we were there, that the certified copy should be there. Sometimes it's there in the parent contract, like in general conditions of contract, there is
Yes.
a provision.
Yes. But my learned friend did some research. Delhi, Karnataka, Orissa, MP, Gujarat don't require either original or certified copy. But now my submission 11(6) says the jurisdiction is so limited. I can tender my agreement and say this is a copy of the agreement. It need not be certified. It need not be original.
No, the issue probably what I could make out from the
Yes.
judgment is they've said certified copy refers to public documents.
Yes.
Certified copies of public documents.
No, what they say certified copy or true copy is the Xerox copy must show that stamp has been paid. What was argued was the Xerox copy will
Show
show
that.
stamping.
But then they have not overruled Hari Om Agrawal and
No, no, no. They're not. My only submission is 11.6a must be given a full play. And now there is no need to get into original certified copy and so on.
because overruling that would have meant the whole case law which has been
Yes,
built up over
quite,
the
yes.
years.
That would again not necessary also. So, my lord. Yes. So, my lord, I'll just conclude because. Section. Lord, I have
Be right. I mean, just apropos what both my learned CMO's colleagues said, we can title this proceeding as in re the interplay between the Indian Stamp Act and the Arbitration and Conciliation Act 1996.
or like, yeah, or in real section 11.6a of the Arbitration Act. Like,
Right under section.
the
8
Arbitration
also.
Act. Okay.
But 1160 will become very broad.
Very
We are
well.
considering the stamp issue.
Very well, very well.
तो आप ऐसा title कर दीजिए. Should we say whether Suryakan, Jamshed and
Which means that section 9 will also be considered.
I was about to ask, because I've dealt with 11.6a. I've finished, my lord. If your lordship wants me to just give briefly on the impact of stamped qua section 8 and section 9, I'll make my submission, then I've finished, my lord.
Would your, then say the interplay between an arbitration agreement and the Stamp Act?
That's better.
Because for institutions, 11.6a would not even arise.
My lord, it'll be interplay of arbitration agreement,
The
stamp
interplay
act and
between
contract.
Arbitration agreements
Stamp act.
under the Arbitration and Conciliation Act 1996 and the Indian Stamp Act
1899 and the contract act also. Okay.
Contract Act is an argument, right?
Okay, very well. So, my lord, should I deal with section 8 and 9 for 5 minutes after lunch, or shall I leave it at the moment? Because we are dealing 11.6a per se.
It's important because in the 20.
All right, then I will deal with it in 10 minutes.
We'll consider whether to expand the ambit.
Yes, but I'll just make my
We're
submission.
now almost wrapping up, so another
Finish, I
5
finished.
minutes and.
I finished.
And this side, we request today, end of the day is the deadline.